And as we had said, the judgment, the pronouncement for the Bilkis Bano case has begun, and the breaking news is that the judgment being pronounced by a two-judges bench headed by Justice B.V. Nagaratna. Now the pronouncement has begun, and what we are learning so far from the pronouncement is that the punishment has to be inflicted not for vengeance but for reformation, is what Justice Nagaratna has said. Now, a woman deserves respect to whatever fate she may follow. This has been further added by Justice Nagaratna. These are the excerpts we are bringing to you from the Supreme Court proceedings. And Justice Nagaratna then reads that the question that would be answered by the judgment, the petition by the petitioner, that is Bilkis Bano, is maintainable. Consideration of whether PIL is maintainable or not is academic and is kept open. This is the judgment that we are receiving so far from the Supreme Court. And we'll cut across to our legal correspondent and colleague Ananya Bhatnagar. Ananya, very good morning to you. Well, do bring us more details and understanding with regards to what's been said, wherein it said that punishment, the petition filed by Bilkis Bano is maintainable. That's what the Supreme Court has said, we are learning.
Well, definitely the Supreme Court bench headed by Justice B.V. Nagaratna and Ujjwal Bhuyan is in the process of pronouncing their judgment when it comes to the challenge to the remission that was granted to these 11 convicts in the Bilkis Bano gang rape case. Remember that there were various questions before the Supreme Court, number one being whether or not that petition that was filed by Bilkis Bano was maintainable in nature before the Supreme Court. Can Bilkis Bano actually challenge this particular remission that was granted to these convicts? The Supreme Court's answer to it is very, very clearly yes. They say that, you know, the convict was well within its right to actually come out. The petitioner was well within its right to challenge that particular remission. The next question that was there with regards to were the various PILs that were filed not only by TMC's Mahua Moitra but various other people, including Suhasini Ali as well, to which the Supreme Court said that, you know, this is not the appropriate stage, and this is much more of an academic question when it comes to, you know, whether or not a PIL is maintainable in a criminal matter or not, because already the petitioner has knocked the doors of the Supreme Court and it does not feel so that, you know, there should be a decision on that, and that's the reason why that issue has now been kept open. Another issue that was there is which policy would be applicable, whether that of the Gujarat government or that of the Maharashtra government, because remember that the trial of this particular case had happened in Mumbai, in Maharashtra, and that's exactly why the question that remained was whether the remission policy of Gujarat would apply or whether the remission policy of the Maharashtra government would actually apply, to which the Supreme Court is answering that particular question at this point of time, and very, very clearly it's saying that, you know, the place of occurrence of a crime and the place of imprisonment is not relevant for consideration, that is the state of Gujarat in this particular case. It also go on to say that the intention of Parliament is to hold that the government where the offender is tried and sentenced is the appropriate government, emphasis on the place of trial rather than the place where the offence has been committed. So basically the Supreme Court going on to say that, you know, the remission policy of Maharashtra was something that should have been applicable. The Supreme Court is also going on to say that the government of the state where the offender is sentenced is the appropriate government to grant remission, not the government of the state where the offence has taken place. Justice Nagaratna go on to say that it is not the government of the state where the offence took place or the offenders are imprisoned which is the appropriate government for remission. The Supreme Court very, very categorically has now held that the Gujarat was not competent to pass the remission orders, clearly saying that the Gujarat government's policy was not applicable in this particular case. Big setback coming into the convicts into this particular case. What is next is that, you know, on this ground alone the Gujarat government lacked competence. The writ petitions are liable to be allowed and the orders are liable to be declared in nullity. A big breaking news coming in for our viewers. The Supreme Court holding that the remission granted to all of those 11 convicts was illegal in nature solely on the ground that the remission policy of Maharashtra had to be applied because the trial in that case had taken place there. The whole trial took place there. They were sentenced in Maharashtra, though they're undergoing that sentence in Gujarat, though the offence took place in Gujarat. But the Parliament, when it had framed a law with regards to remission, it very, very categorically and clearly stated that the remission policy of the state where the trial had taken place would actually be having in. It's just big breaking news, Shreya, that's coming in for our viewers from the topmost court of the country. All these 11 convicts would have to go back to the jail. whole remission orders of the Gujarat government have been nullified by the Supreme Court solely on the ground that the remission policy of Maharashtra was the more applicable one in this particular case.
Right, Ananya. Ananya, yes, definitely. That's a big breaking news for all our viewers out there. All 11 convicts, as per the judgment, as per what's been said by the Supreme Court, will have to go back to jail because it's been said that the remission was illegal because Gujarat government was way out of its way to have passed this remission in the first place. It was the Maharashtra government's judgment that should have taken place, and hence the remission order now stands nullified. We'll go back to Ananya to understand and get more perspective on what's exactly come out from the Supreme Court with regards to the Bilkis Bano judgment. Ananya, coming back to you, firstly, just to set perspective and context for our viewers, if you could just take us briefly through on what grounds was that remission in the first place passed by the Gujarat government, and secondly, as we just mentioned that the 11 convicts are to go back to jail again, what's next in this case for both Bilkis Bano? What exactly is the procedure next that's to be followed?
Well, now these convicts would have to surrender before, in fact, the Gujarat police, and they will be sent back to the jail. The Supreme Court very clearly holding that the state of Gujarat was not competent to pass the remission orders. The dictation is still continuing. Other aspects are being discussed, and the Supreme Court also going on to say, and I'll read out that particular observation by Justice B.V. Nagaratna, that the writ petition in which direction to the Gujarat government to consider the remission was filed by the convicts is suppressing the fact. There are various facts that have been suppressed. He also made misleading statement. The earlier judgment of the Bombay High Court, the opinion of the presiding judge were not revealed in the petition, where it was stated that the remission policy of Gujarat has to be applied by the convicts. They had approached the Supreme Court. Remember, that was the judgment of Justice Ajay Rastogi in 2021, where these convicts were, it was stated that the remission policy of Gujarat would apply, but Justice B.V. Nagaratna, going into the documents, going into that particular petition and that judgment, very categorically noting that various facts were suppressed by these convicts from the Supreme Court, and that's exactly why the Supreme Court reached to a wrong conclusion, and that now has been set aside very categorically and clearly, holding that the remission policy of Maharashtra is to apply to all of these convicts. So a big setback coming in for these convicts in this particular case, very clearly and categorically holding that the Gujarat government lacked competence. The Gujarat government is not the right remission policy makers. The Gujarat government is Gujarat government's policy is not the right policy that should have been applied in this particular case, and it was the state of Maharashtra that had to apply its remission policy while considering the remission application of all of these convicts. A big setback coming in from a bench headed by Justice B.V. Nagaratna and Justice Ujjwal Bhuyan of the Supreme Court to these 11 convicts in the Bilkis Bano rape case. A big judgment coming in, a big relief to Bilkis Bano coming in from the topmost court of the country. Remember that the petitioners had constantly argued that the remission policy of Maharashtra would apply. They had also argued that this was a crime that was much heinous in nature. Remember that in 2002, when this gang rape had actually happened, Bilkis Bano was pregnant. She was raped in front of 14 of her family members, and her another child who was an infant was thrown to the ground mercilessly by these convicts, and that was argued by these petitioners, by Advocate Shobha Gupta, who was appearing for Bilkis Bano, and a big relief now coming in, a big relief coming in for Bilkis Bano, and a big setback coming in for these 11 convicts.
Right, Ananya. Ananya, also help us understand with regards to the PIL, whether that is maintainable or not. You were mentioning earlier that it is an academic question. How is that to play out, and what exactly is the procedure for that?
Well, the Supreme Court has kept that question open as to whether or not a PIL is maintainable in this particular case, whether a PIL can actually come in when it comes to challenging of a particular remission policy. The Supreme Court has not gone into that question, not gone on and deliberated on that particular question, because already Bilkis Bano had approached the Supreme Court, and there was no need of those PILs to be considered or not considered, and that's why the Supreme Court has not given out much time on as to whether or not these PILs are maintainable in nature or not maintainable in nature. The issue has been kept open for some another case, and that is a very secondary question. The big question that has been answered by the topmost court of the country is that if at all a remission policy has to be considered, if at all the trial had taken place in another state, then the remission policy of that state where the trial had taken place, where these particular people were sentenced, is something that would apply. In this case, that is the state of Maharashtra and not the state of Gujarat, and that's exactly why the setback comes in for these 11 convicts, a big relief coming in for, in fact, the Bilkis Bano in this particular case.